Hello, this is Vin Banj from Taylor Wessing. Welcome to our webinar today. Today's webinar is part of our monthly webinar program where we bring you our expertise and views on topical data protection issues. Our regular attendees will be very familiar with our previous topics, which have included issues such as cookies, data security, mobile apps and privacy. We've also looked at some of the more trickier areas such as cloud computing, data transfers, and last month we looked at the issue of bring your own device and the mobile workforce. Recordings of those webinars are still available if you missed them and you still wish to engage with us on those particular topics. Today we will be taking a look at the topic of data protection policies. For those of you who are new to Taylor Wessing or new to our monthly webinar program, welcome to you. As you will see from the slide, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, providing a full-service law firm offering from our office footprint, which spans across Northern, Central and Eastern Europe, the Middle East and Asia. We've listed more details about the firm on the slide deck for your reference. Today's webinar is brought to you by Taylor Wessing's International Data Protection Practice. Our team advises on all aspects of data protection and information law from our office footprint, which is a global 22-partner-driven team, and also complemented by our international network of data privacy law specialists. We are proud to have recently launched our brand new website specifically for all things data protection, and that's Taylor Wessing's Global Data Hub. From this site you'll be able to access news, weekly updates, also with a monthly mail shot on a particular topical issues. So every month we end up looking at issues that are raising concerns or challenges in the data privacy space. This month our articles will also be focusing on the topic of data protection policies. From the Global Data Hub you can also access webinars, events, both forthcoming and also archived. Also you'll find the availability of our groundbreaking risk maps. These provide you with an at-a-glance view of data protection issues with an interactive feature for different countries. My name is Vin Banj. I'm head of the UK Data Protection Practice, and today I'm going to be presenting alongside Sally Enro, who's a senior member of the team here at Taylor Wessing. Our profile is there for you on the slide if you wish to look at that for your own reference. So let's take a look at the agenda for today before I hand over to Sally, who's going to walk us through certainly the front part and front half of today's webinar. The topic, as I said, is data protection policies, and we're going to look at a variety of issues that impact on this particular topic. We will start with an introduction, looking at the role of a policy, its importance and the value, and then we're going to look at why you should use data protection policies, and some of those reasons are listed for you there, including legal grounds, accountability, anticipating risks, and also some of the practical and commercial benefits. These are the source points and drivers for having a data protection policy. We're going to be looking at those as we go through the webinar. Then we'll just take a more of a practical and an area-specific look at privacy policies, looking at the concept of fair collection policies, both online and in the context of apps, for example. Then I'm going to be taking a look at this subject with a particular slant on employment and employee policies, data management policies, and also data security policies and how they fit into this overall topic and key areas for you to look out for. Then I'll hand back to Sally, who's going to be giving us a final wrap-up on making policies work, the importance of making policies work and how that fits into the overall scheme, before Sally just walks us through some of the polling questions which we have in the usual manner towards the end. Don't forget, if you have any questions, please feel free to send those through following the instructions you'll be given at the beginning. If you send those through during the course of the webinar, we'll endeavour to pick them up at the end and answer them after the polling questions. Sally.
Thanks, Ben. Data on individuals is increasingly a core asset of organisations, and many organisations now find they need to take a more strategic approach to safeguarding and managing compliance of these assets. This is where policies can come in. But perhaps we ought to step back and think about what we actually mean by a policy. Typically, it's a principle, or an intent, or a decision by an organisation on how it achieves certain outcomes. Policies often reflect an agreement on an issue by the management or board, and they're adopted at that level. They don't necessarily provide detailed information on the background to an issue, or set out the steps that achieve the outcome. That's more the role of a procedure. Instead, a policy is a guide to actions, and the procedure is the step-by-step way to achieve that action. Policies may be for purely operational or regulatory purposes, or even have more of a PR objective. So they could be a public mission-facing statement of an organisation's commitment to processing personal data in a particular way, such as with a general data protection policy. Or they could be internal business policies that are directed at employees and designed to foster certain behaviours, limit actions, or drive forward good practices. It's important to understand why we should use policies, not least because an important part of getting policy off the ground is to get the buy-in of the decision makers. So these reasons need to be understood and then communicated to the management. So first we have the legal reasons. And to understand these, we need to look to Europe and to the EU Data Protection Directive. The 27 EU member states are legally obliged by their treaty obligations to implement the terms of the directive into their national laws, and in the UK this has been implemented through the Data Protection Act 1998. Now, the directive aimed for harmonisation of data protection standards, yet differences in national approaches to implementing the directive and combining that with different cultural, judicial and political approaches to the subject of data protection generally has meant that this objective hasn't become a reality. Understanding these differences can also be particularly important for organisations that need to create policies for a group or a network of organisations that cross national borders. When we've got the core concepts of data protection law, we understand that the main legal responsibility for the processing of personal data will rest with the data controller. It's the controller who ultimately decides how personal data are processed. The controller also bears the main responsibility for compliance and has that liability for any breaches of the law. Although there are a few direct or explicit mandates in the UK data protection law for data controllers to use policies, they are a necessary way that compliance is achieved in practice, and there's an implicit presumption that policies are needed to deliver compliance. Central to compliance by a data controller with the data protection law are the 8 data protection principles, and these principles, as you probably know, comprise enforceable, common sense standards for the way that personal data are collected, managed and used. The principles span the life cycle of personal data, from collection, ongoing management, through to eventual archiving and deletion. Yet these principles are drafted in very broad terms. They use very non-specific words like adequate, fair, appropriate. The regulators have issued guidance on how the principles apply to particular circumstances, but in broad terms it's up to the controller to interpret these principles and determine how best to comply with them in practice. And again, this is where policies can help. There are also other legal reasons for using policies. So in the e-privacy regulations implementing the separate EU directive on this subject, these can include things like defining the position of the organisation on marketing and electronic communications, deciding how best to communicate information to individuals across different collection channels, establishing whether to collect consents and the use of fair collection notices, and highlighting the processes of assessing the impact of cookies and other information gathering. The policies that communicate why and in what way the organisation may monitor employees, for example, employee communications, will also be important to avoiding any potential criminal liabilities under the Regulation of Investigatory Powers Act, as well as complying with the general fair and lawful processing obligations of the data protection law I just mentioned. Then there are separate standards or requirements that relate to security, combined with obligations under the 7th Data Protection Principle. So appropriate organisational and technical security measures are needed to prevent personal data from being accidentally or deliberately compromised. So this, for example, might require a documented security policy that sets out the objectives and responsibilities of security within the organisation, and we'll return to this subject later. Looking ahead, it's also worth noting that this legal presumption in favour of using policies will become a direct legal obligation under the proposed data protection regulations. In other words, an obligation to have to document compliance. You can learn more about the regulation and these obligations in our March webinar on the subject, and that's available through our Global Data Hub website. We can see how important policies are in underwriting compliance. If we look at the enforcement priorities of the regulator of the UK Data Protection Law, the Information Commissioner. So first, the Information Commissioner has the power to conduct audits. These powers are limited at present to central government organisations and designated public authorities under the DPA and for communication service providers under the e-privacy regulations. But the Information Commissioner does also have some success in twisting the arm of other data controllers into agreeing to consensual audits. So under these audits, the parties agree on the focus areas, but there will always be priority areas for the ICO when he's investigating or conducting an audit, and these nearly always include data protection governance. In other words, what organisational structure, policies, procedures have been implemented to ensure compliance. The Information Commissioner uses the existence of policies and supporting procedures as key evidence for compliance for governance, but also across other core audit areas. In cases where there's a breach of the Data Protection Act requiring the compliance of the organisation to be assessed, then the view of the IC on the Information Commissioner on the compliance or otherwise of the organisation and on the level of any formal action the Information Commissioner takes will be strongly influenced by the presence or absence of policies. This may be important in assessing levels of accountability, for example. Let's say there's been an offence of unlawful obtaining of data that's been committed by an employee under Section 55 of the Act. The extent to which the Information Commissioner decides the employer is also liable for a breach of the 7th security principle may depend on the extent to which the employee understood they shouldn't have done what they did. So the existence of policies supported by active monitoring and training therefore can go some way to mitigate the accountability of the organisation for the employee's actions. Complaint handling policies can also be an important tool in keeping the Information Commissioner at bay. The Information Commissioner does not always have significant time or resources to be proactive on compliance, and therefore much enforcement activity is driven by complaints made to his office. In many cases, these complaints are made because the organisation simply didn't respond to an individual. Indeed, when we look at the top areas of complaints made to the Information Commissioner, these are all areas where effective policies can make the greatest difference, such as failure to respond to a subject access request, which can account for between 40 to 45% of complaints in some cases. Failure to take somebody off a marketing file, a failure to prevent the disclosure of data, or a failure to correct or update records, again, account for a significant proportion of the complaints the Information Commissioner receives. Not surprisingly, the presence or absence of policies can also have a significant impact on the level of action the Information Commissioner takes. The Information Commissioner's monetary penalties guidance makes clear the importance of policies in mitigating the fines that he applies. In the guidance, the Information Commissioner explains that in deciding whether a person took reasonable steps to prevent a breach to which a fine may apply, he would consider whether there was evidence of appropriate policies or procedures in place relevant to the area where the contravention occurred. Yet having policies in place is not enough. The Information Commissioner will also look for evidence that employees are aware of the policies and their content, and that the policies are regularly communicated to employees, and there's training on the terms of the policies. For example, in a press release accompanying his fine of £140,000 to Midlothian Council for making disclosures of sensitive data related to children and their carers back in 2012, the Information Commissioner made clear that the breaches could have been avoided if the Council had put adequate data protection policies in place and implemented training checks. Legal reasons for using policies are therefore very important. However, avoiding damage to brand or reputation are just as dangerous, if not more so, for an organisation than any enforcement action by the Information Commissioner or any fine he might apply. So avoiding adverse headlines or PR should also be key drivers for the rollout of a structured programme of data protection compliance policies. Adverse headlines may not just be damaging to the trust and confidence of the organisation, but undermine shareholder confidence as well, or sideline business resources into managing potentially costly disputes with suppliers or clients who might get involved in or affected by the breach. may also take employee resources away from their main role, having to deal with a regulator or disgruntled employees or having to fix the problem. There may also be other significant action from other regulators to consider. However, it's not just about avoiding bad PR or legal consequences. There are also important business benefits from the use of policies. Policies can bring uniformity, they can bring consistency in decision-making and operations. When people understand what needs to be done, then less time is wasted reinventing the wheel. To help an organisation to communicate its approaches to individuals with more transparency. With that transparency then comes more confidence of good practice, and with confidence, individuals are likely to have more tolerance. A study last year by the Future Foundation with the Direct Marketing Association found that 58% of participants cited trust as the most important factor for them in deciding whether to share their data. Policies also make personal data management infrastructure and systems more resilient by improving the ability of the organisation to respond and recover quickly from incidents or disasters. If we now take a look at some practical reasons why we use policies, the clearest example can be found in the first principle. An important aspect of this policy is that personal data is processed fairly as well as lawfully. The Act doesn't comprehensively explain what fair processing is, although the schedule to the Act explains that personal data will be processed fairly only if the data controller has ensured, as far as reasonably practicable, that the data subject has been provided with or has had information made readily available to them. The words "as far as reasonably practical" make it clear that there is flexibility in how organisations give fair processing information, including communicating it. In practice, this means individuals are given a fair processing notice by which they understand certain core information, which is who they're giving their personal information to, what purposes the personal data is going to be used for, and any other uses or disclosures of the information that might not be expected or that the individual might find deceptive, misleading, or might generally object to. The Information Commission's Fair Processing Code is helpful here, that it pulls out examples of the information expected to be found in fair processing notices, but it's also important to consider the particular context in which the information is being collected when putting together these notices. So if we take, for example, a website privacy policy, in addition to the core who, what, and why information that policy should make clear, individuals should also understand their rights to access their data, to get their data corrected or erased, to object to the use of their data for marketing purposes. They should also be made aware of any transfers of their data and have a general understanding and confidence in the security measures applied to the data. In addition, a specific environment needs to be considered, so including the e-privacy requirements to give information and get consent to the use of cookies. The level of information that has to be provided about cookies may differ depending on whether the policy is explaining cookie use to an average online consumer or it's a message that's going out to an experienced IT professional on a B2B site. The cookie information can form part of the privacy policy or be a separate policy in its own right. In particular, users should be informed of the names of the cookies, their purposes, the types of cookies explaining if these are strictly necessary or analytic or performance or targeting cookies. Information on the duration of the cookie should also be given, as well as information on how to disable specific cookies or generally manage a user's cookie preferences. The information should present policy or policies as part of a layered approach to providing transparency. Information should be displayed as a prominent link from the landing and other pages of the website, in addition to banners or other information that alert the visitor to the use of cookies. Increasingly, people also access online content or applications through their mobile devices, such as smartphones or tablets. And the need to provide information to users about the information that's collected there is equally important. In practice, this means that every app, for example, should have a privacy policy. As with the website privacy policy, there will be core information that should be provided to users before they install the app about who, what, and why around the use of their information, in addition to information about the risks and the transparency requirements that are specific to the processing of personal data on smart devices. More information on this is found in an opinion published by the Working Party of EU experts, the data protection experts, the Article 29 Working Party, This is an opinion on data protection and applications. The view of the Working Party points to the importance of providing this fundamental information on the use of data, but also stresses the importance of being clear about whether there are any specific features of the device or that the app they may have access to that may need to be explained and under what circumstances this may occur. So this might include whether the app has access to the use of sensors, such as proximity readers or movement detectors, compasses, gyroscopes, or accelerometers, which might indicate what the user is doing, or perhaps the direction they're travelling in, or the speed in which they're moving. It might also include access to use of front and rear cameras of the device to access video or take photographs, or it may have the ability to use the microphone to capture and record audio content. Then there's also the information about the user's location that the app may fix through geolocation services. The Working Party view is that app policies should be easy to locate both before the app is installed and after installation in the body of the app itself. It's recognised that the small screen of a phone or a device may present a challenge in presenting information to a user in a clear way, but the use of icons or video or audio or layered notices with links are all pointed to as ways in which information can be made easy for a user to access. There's a view here that clearly app developers are very creative people, and in the opinion of the Working Party, they should have no trouble at all in turning their skills to creating innovative solutions for this area in just the same way as they do in producing and presenting their general app content. Importantly, an app should be consistent with any others that the organisation uses for other channels, such as the privacy policy, so that people are clear about what information is collected from them and in what context.
Thank you, Sally. Let's take a look at the subject from the perspective of the employer and employee relationship. Given how data-rich employment context is, employee data protection policies will help to ensure compliance with data protection laws and give greater flexibility on certain areas of employment activity. For example, where an employer may need to monitor the employee's use of email or internet or other work devices as part of perhaps an investigation, etc. And that really makes it fundamental to having a data protection policy within the employment context, not only dealing with that issue, but a whole broader range of other data protection issues. Just to take a step back, all employers will collect and use personal data belonging to job applicants, employees or workers, and as a result they'll be required to comply with data protection laws which are designed to protect processing of this sort of data, and that will apply in the UK as it will pretty much apply across every other member state in Europe and beyond within the employment context. And by having an employee data protection policy, an employer can reduce the risk of claims for failing to comply with these laws, and also give itself greater flexibility in contexts such as the one I've just mentioned, monitoring the use of email and use of employers' systems as is required. Now, it's the data protection framework that requires that an employer must have a lawful reason for collecting and using personal data and ensure that this is processed fairly for a limited period of time, kept accurate, and also kept secure. Personal data is information that relates to a living individual or a living person who can be identified from that data. So, in an employment context, this will include the information that relates to employees, information that is on a personnel file, for example, and any expression or opinion about or an understanding of facts concerning that particular individual, whether they are an actual employee, potential employee, or a former employee. There are some rules around carving out some information which is perhaps not personal and is more around business, day-to-day business correspondence, for example, but that's really outside the scope of what we're talking about here. We're really talking about the data set which is gained from the employer-employee relationship, which is quite vast. The protection of employee data by employers is required throughout the employment relationship and beyond. For example, employers will collect personal data when they are recruiting employees by requesting or receiving personal data in job application forms or online submissions, CVs or curriculum vitae. and they will do that either during employment or perhaps in relation to salary and benefits entitlements, performance reviews, and sometimes disciplinary and grievance procedures. It can happen after the employment, for example, where the employers have obligations to retain data for certain periods of time. So, as an example, in the UK, there is a requirement to keep statutory sick pay payment data, which must be kept for a period of up to 3 years. In addition, and from time to time, as part of the routine checks or a specific investigation, an employer may wish to monitor or check an employee's email or internet usage, or general systems usage. And that will inevitably result in the employer accessing or using his or her personal data. So we are talking about the processing of personal data. The purpose of a data protection policy in this context is to set out the conditions under which the employer will process personal data and ensure that everyone in the business is aware of their individual responsibilities and also aware of the employer's expectations with regards to privacy. Not all employers will choose to have data protection policies, but most that we see who are significantly involved in processing employee data will do so. And it's become best practice to actually have a policy that will set out a method by which internal data protection compliance can be achieved. And there are risks to not achieving compliance this way, some of which Sally has already set out. Certainly if an individual employee or ex-employee could potentially claim that they suffered damage that's caused by the employer's breach of its obligations, or that he or she could potentially bring claims for breach of contract, constructive unfair dismissal, and a whole array of other employment or labour laws, which often have intrinsically linked to it a data protection reason. Now, I mention these in the context of the UK, but clearly in other countries there is perhaps a stronger need to have a data protection policy, where not only is it a requirement under the framework of data protection law, but also you will need it as an additional step to perhaps consult with your works councils, maybe even get an agreement that that particular employee data protection policy is acceptable to the works council. The data protection policy in an employment context should be tailored to an employer's business to take account of the structure of its organisation, its resources, and the particular personal data that it may process. Generally speaking, no two businesses are alike, and that really applies in the employment context as much as it applies in the consumer or any other data-rich context. So making it specific for your organisation is key. The policy must also be communicated to staff and monitored in practice. So simply writing a policy and not drawing this to the attention of employees is just not enough. Ideally, an employee policy in this context should identify a compliance manager who is responsible for reviewing, implementing and monitoring compliance with the policy. The policy should recognise that job applicants and current and former employees and workers are covered by the data protection requirements. In addition, the policy should explain what amounts to personal data, where and what type of information may be held, and how this may be processed, and acknowledge that this will only occur if, for certain contexts, the employee has given consent, where consent is a necessary requirement under your particular data protection framework requirement. The employee policy should also briefly set out the measures taken by the employer to ensure that there are appropriate security measures in place to safeguard employee data, and address how this will be protected if the employer intends to transfer employee data outside the European Economic Area to a country that's not deemed by the EEA to have a sufficient degree of data protection within its data protection regime. I would also suggest that a forward-thinking employer can perhaps put itself in a much stronger position if it was to check and investigate facts, for example, for legitimate business reasons, including investigations, grievances, and potential instances of poor performance or misconduct. If you have those grounds covered in a sufficient policy statement on employee monitoring, either as part of the data protection policy or as part of a separate IT user policy. In particular, the statement should explain that the use of its IT systems, whether that's email, internet, telephones, mobile devices, and so on, may be monitored from time to time, and that the employees should perhaps not expect a degree of privacy as far as that is used within the employment context and certainly on the employer's systems. In addition, an employer could also include a contractual right to monitor as part of a data protection clause in an employment contract. That's something that will have to be assessed on a country-by-country basis, depending on what the local rules are for having consent and having such matters addressed by contract. All in all, an employer will always be required to act reasonably in a manner that does not damage trust and confidence in employment. And this statement and this data protection clause type of approach will also set out the employer's expectations and may enable a more robust investigation to be carried out with a lower risk environment. As I say, country-specific expectations do need to be observed in that regard. Most organisations will, because they are so different, have their own particular degree of complexities or specific issues that arise in terms of their data capture and the data life cycle. Therefore, it may be necessary to break down some of the elements that I've just mentioned into further detail and perhaps into further policies that are separated out from the overall data protection policy into perhaps a cluster or an umbrella that includes several specific policies that fit inside that structure. For example, an acceptable use policy, as already mentioned, but now perhaps with a more specific focus on systems use, home working, access control, bring your own device, so on and so forth. Social media is perhaps another example where a specific policy may be required, depending on how your staff use social media, what the data protection interaction is, and how that links with your other corporate policies around corporate messaging. Perhaps a separate section or even a policy on data subjects' rights. What are your employees' rights as far as data protection frameworks are concerned, such as subject access rights, perhaps rights in relation to marketing and opting out, if you are also using your employees as customers, for example. Depending on your organisation, that may also be set out with specific reference, perhaps separately or linked into the same policy. Now, all this is important not only to ensure the rights of data subjects, but also as a framework for data integrity. And let's not forget, fundamentally, it's all about control and data integrity. And policies are very helpful in that they can provide for control and data protection. Compliance is no exception to that need for control. Management of personal data is a matter of documentation and also a matter of influencing human behavior. What do I mean by that? It's a policy or a documented approach that helps employees to understand that they need to make the right decisions and the right judgments when they're handling data, personal data in particular, within an employment context. From collection, recording, input, enhancement or updating personal data, either in relation to other employees or their responsibilities in terms of personal data within the wider ecosphere of your particular organizations. So it may not be employee data alone, it may be data in relation to customers, either consumers or business customers. So having a documented approach either within a data protection policy or a data protection operating manual, or ideally having your operating manuals reviewed for data protection compliance, so it's one source. That level of documented approach will be important. It will be important for employees to know where they should be looking to ensure data protection compliance and to discharge their individual responsibilities. And also be important to tell employees what is expected of them. In effect, the do's and don'ts with regard to employees handling or not mishandling personal data. And this can really range from generic to more specific policies such as data retention. If we just look at that point alone, the Data Protection Act and the Data Protection Framework within the EU does not give you prescribed data retention periods. So a data retention policy is one that factors in data protection compliance from a variety of different perspectives. The DPA framework will say data should not be kept longer than is necessary for the purpose for which it was collected. Quite a nebulous concept in its own right. The only way to tackle it is to actually adopt a classification approach. Now, not all areas of operation require a more in-depth approach in that way. But one area that certainly does is the topic of information and data security policies within the employment context. And we've looked at the topic of data security within our webinar program. We looked at it last year, so there's greater detail and background on data security, which is still available on that webinar recording if you want a broader and more in-depth look at this particular aspect. But let's just toy on this for a moment, because it's quite important to the policy set that exists for data protection compliance within a organisational and certainly an employment environment. The scope of the seventh principle, or Article 17, if you're looking at this in EU directive terms, is that appropriate technical and organisational security measures need to be taken to safeguard against specific risks. And these risks are risks such as unauthorised or unlawful processing, accidental loss or destruction or damage to personal data. And you need to really look at and break down the language of the seventh principle to understand the scope of what is required. It tells you the types of risks to address, such as unauthorised or unlawful processing. This language also links back to key definitions under the data protection framework, such as personal data, processing, data controller. Therefore, it applies to all aspects of data processing, from collection, whether that's data that's collected on paper, by voice means, whether it's over the telephone or other electronic means, and it's every use and stage as it goes through its life cycle within your organisation. There's also a clear link between security and other principles. I mentioned data retention, and that's perhaps one of the clear examples that we have. When you no longer need data, you should get rid of it, and that's the fundamental principle. But in complying with that, it also reduces the risk if you get rid of the data when you no longer need it, because otherwise, for as long as you have it, you have the inherent risk that's attached to it with regards to data security. So think of these obligations in the round. So how does this dovetail into a data security policy? Preparation of the policy. It's very important to address the preparation right at the very outset. So this is all about going back to the risk assessment. There's Principle 7, Article 17 risks that will drive the content of the policy, and they will also drive the technical and organisational measures required in your security policy. The scope and explanation of the policy is crucial, because as a data management tool, this will set out who this policy applies to and what is expected of the employee, whether perhaps the application is wider. Does this extend to contractors? Does this extend to your counterparties, for example? So often we see that this just isn't clear enough and can impact upon the ability to enforce the policy when there is perhaps a breach of it, or being aware of where there are enforcement gaps if the scope just hasn't been clearly established at the beginning. Also, a lack of clarity here can create a fundamental weakness in the policy itself. There is also the section of the policy in terms of IT security that will have to deal with the real nitty-gritty procedures. And this is where you get into the detail of the policy, and we're not going to do that here. As I said, that was covered on a previous webinar, but suffice to say that this is where you match your controls and the direction against the risks identified that are applicable for your organisation. And they're both from a technical perspective, whether you're talking about firewalls, or whether you're talking about architecture around particular server farms, or whether you're looking at this from an organisational perspective, the people side of security policies. And this may, for example, embed itself into data processor procedures, your third-party procedures when you are passing data onto a data processor, where you have requirements around data due diligence. So what are your checklists, and what do they say? And are those due diligence checklists appended to your information security policy, or is that a separate area that's cross-referenced? Where do you go for a reference to contractual clauses that also need to be incorporated? And these contractual clauses are a requirement under the seventh principle and reflected accordingly from Article 17 of the EU Directive. All technical and organisational detailed procedures that need to be set out in the security policy. The security policy should also deal with other key issues such as access control, authorizations and permissions in terms of who can access certain systems, who has the authority to remove access or grant access, backup procedures, archives, and also measuring compliance. Not only just playing lip service to measuring compliance, but a genuine measurement of how effective the policy really is and how this is conducted, whether it's spot checks, whether it's detailed audits, whether it's a form of maturity assessments or privacy by design that kicks in when there's a new product that needs to apply the security measure. Perhaps this is more of a Venn diagram approach, and there's perhaps several of these areas that need to apply depending on which aspect of your data lifecycle you're really concerned with. Instant procedures are also something you should expect to at least be cross-referenced within an IT security policy, if not dealt with in a degree of detail. So if you had a breach, how would you deal with that breach? Where is that set out? Where is it set out that says who will do what in terms of responding to the data breach? What is that overall response framework, and what does it look like? Who has the appropriate authorities to carry out investigations, and so on and so forth. These also need to be either cross-referenced or set out within the security policy framework. Personnel issues, just as I mentioned earlier, and that the scope of the policy is important, as is the ability to enforce the policy against your employees. To make very clear what are the consequences if staff breach the policy. It needs to have bites, so make sure it's actually being reviewed not only by your data protection or privacy teams, but also by your employment or labour lawyers to ensure that it works and is enforceable if there is a breach by one of your employees. So it's clear that policies have a role to play in the employment environment, in providing the backbone of data protection governance. But also, it is just that. Policies give you the backbone, and it's the backbone that requires the flesh and muscle to build around it to make sure that the policy really works. So as we now sort of approach the latter stages of the webinar, Sally's just going to look at the broader point of making sure policies actually work.
Thanks, Vin. So finally, policies are only as effective as the approach of the organisation and the commitment it has to making the policy work. It's a good idea to consider the structure of a policy. Will it be, or is it, broad enough to cover the structure of the organisation? This structure may influence how much standardisation or central direction is appropriate. Consider workplace etiquette, values, working language, and habits, as these may all have an influence on the style and approach that a company adopts. Importantly, consider the chain of command and who's going to need to lend their support or buy-in to the policy to make it work, and who will be the person or part of the organisation with the overarching responsibility for the policy, so that, for example, consultation occurs during the development or the review of the policy, that the policy is implemented and that compliance is monitored, that issues are recorded or resolved, and that the policy and procedure are regularly reviewed. Consider how the policy will integrate across the organisation. Approval or endorsement may need to come from several quarters, depending on the audience. Consider the content and presentation. A good policy should have clear structure and include control information that defines the status, the currency and ownership, so that there's a clear protocol for managing the policy going forward. This will also include issue dates and version numbers and a record for the date of the next review set within the policy. Keep the structure simple and clear about the purpose of the policy, who it applies to, and any limitations on its scope. The policy should be clear about any defined terms, and where the policy sets out obligations, then make clear what the rule or obligation is and how it applies and what this means. In terms of language, short sentences have more impact, and take care to be specific. The AP's opinion of the working party, for example, warned against the use of elastic terms in policies that were aimed at users when describing reasons for handling their data, and using terms such as product innovation that are opaque and tell the user nothing. Policies should avoid jargon or overly technical terms, and should consider the audience, particularly when the audience might be children. Active language rather than passive language is generally seen as less bureaucratic and easier to read. In addition, policies should be clear about what actions are mandatory or merely recommended. They should be easy on the eye, use lists or bullets or other ways to make key messages stand out. Policies cannot be effective unless they're provided and explained to all existing and new employees. The Information Commissioner points out to examples of poor policy controls being where there's a lack of perhaps employee awareness of the location of policies or inadequate training against policies. So education on policies and review should be an ongoing process. And last but not least, as Vin has just mentioned, policies are only effective if they're enforced. employee policies should make clear what the consequences of failing to comply with a policy are. The policy can be linked to an employment contract, for example, and employees could be asked to sign up to the policy that they have read and understood its terms. When monitoring and measuring compliance against policies and reviewing their effectiveness, make sure that this is documented and that issues with either the policy or compliance with its terms are reported up as part of an ongoing cycle of review and improvement of policies. Okay, we've now reached our regular polling questions slot. We have a number of questions we would like to ask you to consider in relation to the use of policies. So the first question on this topic is, do you have a suite of existing data protection policies? And it's just simple yes or no answer. Secondly, are employees trained against your policies? Yes or no? Thirdly, do you monitor and measure compliance against your policies? Yes or no? And have you reviewed or updated your policies in the last 12 months? Yes or no?
And as we're waiting for those results just to come through, just to mention that our next webinar is going to be on the 18th of June, Tuesday the 18th of June, and we're going to make a change to the listed topic. We were going to look at the topic of Anglo-German HR data protection issues, which we will still come on to. However, we wanted to visit a topic which is certainly becoming more and more of an interesting topic at the moment, and that's the topic of wearable privacy. So we talked about, back in December when we looked at the year ahead, 2013, we talked about the topic of augmented reality. And we've already seen a particular product that's been launched on the market. So we thought, and there is rumours of other products also hitting the market. So we thought it's a time for us to visit this exciting topic. So that's going to be the topic on the 18th of June, the topic of wearable privacy. We're just still waiting for some of the results to actually click through. Let's see if we've got any of them here yet. No, not quite coming through just yet. What we will do is, it may look as if we have a technical hitch just getting the results to come through to us. We will make sure that we give you the results just as I say that, they'll actually come through. Okay, I can read those through to you now. So the first question on, do you have a suite of data protection policies? 80% of you say yes, you actually operate on having a suite of policies, and 20% of you do not. In terms of our employees actually trained against your policies, this is an interesting one. Only 51% said yes. So it's very much split, half and half there. And that's quite an interesting sign, because most of the breach incidents that you will see certainly reported up at ICO level, and those that we handle almost week in, week out these days, we see that the failures are a result of employees who feel that they're not adequately trained, or it's later assessed that they were not adequately trained against policies. Do you monitor and measure compliance against your policies? Only some 39% of you actually do that. So again, I'm not surprised with that number, having seen the answer to question 2 as well. The final question is, have you reviewed or updated your policy in the last 12 months? We thought it was quite an important question to ask, given what's been going on in the last 12 months or so, with cookies, with apps, with lots of other interesting points around data protection policies. And some 60% of you, 61% say that you have, so perhaps more than the majority have been alive to those issues. So we hope that's been of interest to you, just to learn those statistics. And for now, again, just to repeat, our next webinar is going to be on the 18th of June on the topic of wearable privacy. We really hope you can join us for that particular webinar. And for now, we'd like to say thank you from the team here at Taylor Wessing for joining us on today's webinar. Goodbye.